The March 2026 Visa Bulletin just dropped, and for hundreds of thousands of Indian nationals waiting in the employment-based green card line, one number changed everything. EB-2 India just moved forward by 11 months in a single bulletin. 11 months. In one move. That has not happened in years. But here's the part no one is talking about. EB-3 India did not move at all. Not a single day. And that contrast, that split between EB-2 and EB-3, is the most important thing you need to understand before making any decisions about your green card strategy right now. Stay with me for the next few minutes. What I am about to explain could directly affect your timeline, your filing window, and potentially your entire path to permanent residence. My name is Raymond Crivello. I am a senior immigration analyst and consultant. And on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I do not deal in rumors. I do not deal in fear. I deal in policy, data, and the kind of grounded analysis that actually helps you make informed decisions. Before we go further, I want to be clear about something important. I am not your attorney, and this content is for educational and informational purposes only. Every immigration case is unique. Always consult with a licensed immigration attorney about your specific situation before taking any action. Now, let us get into what just happened. Every month, the U.S. Department of State releases what is called the Visa Bulletin. This document sets the priority dates, essentially the cutoff dates, that determine whether someone in the employment-based or family-based green card line is eligible to move forward in the process. If your priority date is on or before the listed date, your visa number is considered available. There are two charts in the Visa Bulletin. The first is called Final Action Dates. This is the date you need to reach before USCIS can actually approve your green card. The second is called Dates for Filing, and this one is critical for March 2026 because USCIS has authorized the use of the Dates for Filing chart this month. That means if your priority date falls within the Dates for Filing range, you may be able to file your Adjustment of Status application, your I-485, even before your visa number is technically final. That distinction matters enormously, especially this month. Here is why. For EB-2 India, employment-based second preference, which covers professionals with advanced degrees and workers with exceptional ability, the Dates for Filing chart moved forward by approximately 335 days, from around December 2013 to November 1st, 2014. That is 11 months of forward movement in a single bulletin. Let that sink in. If you have been waiting in the EB-2 India line with a priority date in early to mid-2014, this month may have just opened a filing window for you. Now here is where this becomes critical, and this is what many applicants are misunderstanding. EB-3 India, employment-based third preference, which covers skilled workers, professionals without advanced degrees, and other workers, did not move at all. The dates for filing date for EB-3 India remains frozen. No change. This creates a significant tension for a segment of applicants who had previously downgraded their category from EB-2 to EB-3 in order to take advantage of earlier EB-3 movement. For those applicants, March 2026 is a complicated month. Your EB-3 date may not have moved, but your original EB-2 priority date, if you still have it, may now be current or close to current under the Dates for Filing chart. This is why strategy and documentation right now are everything. Let me give you the broader picture before we go deeper. The reason behind this movement is not random. The State Department's own notes on the March 2026 bulletin make clear that forward movement in certain employment-based categories, particularly for Indian nationals, is directly related to a policy-level administrative action. In recent months, visa processing for certain other nationalities has been paused or significantly slowed due to administrative policy decisions. When those visa numbers go unused by other nationalities in a given fiscal year cycle, they do not simply disappear. Under the Immigration and Nationality Act, the INA, unused employment-based visa numbers can be redistributed to other applicants in the same preference category based on availability. In plain terms, because other nationalities were temporarily unable to use their visa allocation, those numbers opened up, and Indian nationals in the EB-2 backlog, one of the longest and most congested backlogs in the entire system, benefited from that redistribution this month. This is administrative policy ripple effect in real time, and it creates both opportunity and uncertainty. Let me put a human face on this. Consider someone like Priya. Priya came to the United States in 2010 on an H-1B visa. She works in software engineering. Her employer sponsored her for a green card under EB-2, and her priority date, the date her I-140 petition was approved, is February 2014. For years, Priya has been watching the Visa Bulletin every single month, hoping her date would move. Some months movement was measured in days. Other months there was retrogression, meaning the cutoff date actually moved backward. Priya has been in this system for over a decade. This month, March 2026, for the first time in years, her February 2014 priority date falls within the dates for filing chart for EB-2 India. If USCIS confirms it will accept dates for filing applications this month, and it has, Priya may now be eligible to file her I-485 adjustment of status application. Filing the I-485 does not mean she gets her green card immediately, but it means she can access critical benefits, employment authorization, advanced parole for international travel, and protection of her priority date while she waits for her final action date to become current. For someone who has waited 12+ years, this filing window is not a small thing. It is a significant milestone. There is one detail most people are missing right now, and I want to be direct about it. Filing under the dates for filing chart is not the same as getting your green card. When you file the I-485 under dates for filing, your case goes into a queue. USCIS will process and approve your application only when your final action date becomes current. The final action date for EB-2 India is still years behind. The dates for filing chart and the final action dates chart are two different things. Movement in one does not automatically mean movement in the other. So what this month gives you is a window, an opportunity to get into the system, lock in your benefits, and protect your place in line. It does not give you a green card this month. Managing that expectation is essential. Applicants who rush to file without proper documentation, without confirming their eligibility, or without consulting a qualified attorney risk delays, requests for evidence, or other complications that could actually set their case back. Now let me explain what is driving this at the policy level because context matters. The State Department does not move dates arbitrarily. Every forward movement, every retrogression, every freeze is driven by visa number calculations tied to the annual employment-based visa cap. The United States allocates approximately 140,000 employment-based green cards per year across all preference categories and all nationalities. Per-country limits prevent any single country from using more than 7% of the total. For India, a country with an extraordinarily large number of employment-based applicants, that 7% cap has created a backlog stretching decades for some categories. The only reason meaningful forward movement happens in a given month is that the total number of available visa numbers exceeds the immediate demand from other sources, whether because of processing pauses, administrative policy shifts, or fiscal year dynamics. The current forward movement in EB-2 India is directly tied to what the State Department itself described as a redistribution effect from paused processing for certain other nationalities. That effect may not be permanent. It may not last more than 1 or 2 bulletin cycles, which is why if you have a February 2014 or earlier priority date in EB-2 India and you are eligible to file, the window in front of you deserves immediate, serious attention. Let me give you a clear, structured action plan. 5 steps you should be taking right now. Step 1. Verify your priority date and your visa category. Pull out your I-140 approval notice. Confirm whether your approved category is EB-2 or EB-3. If you previously downgraded from EB-2 to EB-3, understand that your original EB-2 priority date may still be associated with your I-140 and may be usable if you upgrade back. An attorney can help you evaluate whether that option exists for your case. Step 2. Check whether USCIS has confirmed the use of the dates for filing chart for March 2026. USCIS makes this determination separately each month by posting a policy announcement on its website. The State Department releasing the chart is not enough. USCIS must affirmatively confirm it will accept applications under that chart. Verify this on the uscis.gov website directly. Step 3. Gather your documentation now. If you believe you are eligible to file an I-485, begin assembling your civil documents immediately. Birth certificates, marriage certificates, passport copies, medical exam records. These take time to collect, and filing delays because of missing documents are avoidable. Step 4. Consult a licensed immigration attorney before filing. This is not optional advice. Adjustment of status is a complex process. Issues with your immigration history, travel history, prior status violations, or other factors can affect your eligibility. An attorney can identify complications before they become problems. Step 5. Be cautious of notarios, unauthorized preparers, and anyone who promises guaranteed outcomes. Opportunists often emerge when major Visa Bulletin movement happens. They target immigrant communities with exaggerated promises. Always verify that the person helping you is a licensed attorney in good standing with their state bar. Now let me talk about what we can realistically expect going forward. Based on historical patterns, this kind of large forward movement, 11 months in a single bulletin for EB-2 India, can be followed by one of two things: either continued moderate movement in subsequent months as the redistribution effect continues, or a sharp retrogression as demand catches up with available numbers. If a large volume of applicants file I-485 petitions in March based on this opening, USCIS will begin processing a significant caseload. That increased demand will be reflected in future visa bulletins. It is not unusual to see the State Department pull back dates in subsequent months when early filings create a surge in demand calculations. What this means for you is straightforward. If your date is current now, act now. Do not wait for next month's bulletin assuming the window will still be open at the same level. It may be, it may not. Immigration timelines are inherently uncertain, and the policy environment that created this movement could shift again. Congressional action on comprehensive immigration reform, something that has been debated for decades, could alter these timelines significantly, either by expanding the annual visa cap or by reforming the per-country limits. But congressional legislation requires passage in both chambers and a presidential signature, and any regulatory implementation that follows takes additional time. Do not plan your case around legislation that has not passed. Let me close with something that I think needs to be said plainly. I speak with people every week who have been in the employment-based green card system for 10, 12, 15 years. These are individuals who followed every rule, who maintained status, who renewed their H-1B year after year, who watched their children age out of dependent status because the backlog moved too slowly, who made major life decisions, buying homes, taking jobs, starting families, all against the backdrop of a process that has no guaranteed end date. When the Visa Bulletin moves forward by 11 months in a single cycle, it is not just a policy number changing. For real families, it is a real opening, and those openings deserve to be taken seriously, prepared for carefully, and acted upon with the guidance of qualified professionals. Your immigration status affects more than a piece of paper. It affects your employment, your family's stability, your children's future, your ability to travel, and your long-term path to citizenship. Every update to the Visa Bulletin, every USCIS policy change, every court ruling in this space has the potential to affect cases that are live and active right now. Staying informed is no longer optional. It is essential. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If you found this analysis helpful, please leave a comment below telling me your visa category and your priority date. I read every comment, and I want to know how this bulletin is affecting your situation. Share this video with someone who is waiting in the employment-based green card line. They need this information. And like this video to help accurate, factual immigration analysis reach more people who need it. I will see you in the next update.